I think the three papers were well integrated in the sense that all of them explicated the inherent tension between nationalism and minority rights, and in one case, maybe the tension between liberal democracy and minority rights. This is an issue that is, of course, very pertinent to this country, especially in light of the election results that we all heard about this morning. Regarding the Russia-US nexus, I just want to make one small point, and that is the Bund did not establish a branch in the United States, because the Bund said the Jewish nation ends at the Vistula. What they established in the United States was a support group for the Bund, so which is conceptually a different thing. Okay, so I think we have about 20 minutes for questions and answers. We will gather a few questions, let the speakers answer them, and if we have time, we'll gather another round. So, please, the floor is yours. Yes, please.
I'm Ben Nathans. I have a question sort of for all three panelists, and you can decide to field it how you want. One of the unexpected outcomes of this panel is that we heard more about the ways in which individual rights were inadequate or perceived as inadequate by an American representative than we did the same for Eastern Europe or the Minorities Treaty. So my first question is, in what terms, in what vocabulary was a regime of individual rights perceived as inadequate for the newly independent states of Eastern Europe after the First World War? We jumped right into minority rights as if they were the natural solution to the problem, but I'd like to hear why another equally self-evident, more American-inflected solution seems to have been off the table from the beginning. And then, particularly for Professor Forbath, I learned a lot that I didn't know about Louis Brandeis from this talk, but I'm still trying to square your image of Brandeis with the person who articulated the right to privacy for the first time on a legal level in the United States, the right to be left alone by everybody. That seems difficult to square with this notion of group identities and group rights.
Yoa?
Thank you. My question is also goes to all three panelists, and I was wondering as I was hearing you, you were talking about two things, about the role of law in designing systems of rights, protecting minorities and so forth, and you talked about the role of identity and identity politics. And I was wondering, and it seemed at time that, especially in the Zipper's talk, that the law is not important. What is really doing the work here is the identity politics, and that's why there is no inconsistency between Poland and Israel. It's just, this is a group who wants to keep its identity, and it will do whatever. Doesn't matter what the legal construction is. On the other hand, it seems from the other, I wonder, what is the importance of the legal construction? Or is it just identity politics that is doing the work for the Jews here?
Okay, Scott?
I'll go from these more general and great questions, something more specific. I guess the first question is for Willie, as I guess we meet as someone dealing with history and something with law. I wonder if you could talk a bit more about the American context for developing these ideas, and in particular, at the same time we're talking about the development of Jewish rights and Jewish organizations, we have the development of African American organizations or black organizations, in particular the NAACP, which is happening more or less at the same time, with many of the same people. So could the influence also be coming from American discussions of ethnicity, not so much from a Russian background of communal organization and development, and what kind of, whether or not, and how that changes your picture? And if I may, just a quick question for Marcos, which is a great paper. Also kind of tailing and picking up on Laura's point, Grunbaum is a very different person in Warsaw in 1925 than he is in Gan Shmuel in 1949. Is he expressing, and so I mean, obviously between the words Grunbaum is a political leader, but in Israel, is he still a political leader, a political force? So in that sense, is what you're describing, which is fascinating and wonderful, is it a larger social and political development, or is it just Grunbaum's own personal dilemmas?
I want to echo what people have said, which is all three papers fit together so nicely, and being familiar with all of the work of all three of you, it's still great to learn something new in the presentation over here. And what strikes me is a theme particularly for Marcos and Willie about this question about attention versus a complementary relationship, right, between the nation state and minority rights. Sometimes it sounds like, Marcos, you're saying there's an inherent tension that people are negotiating, and sometimes it sounds like you say there's a compatibility, a complementarity to it. And it's interesting to think about that and then read that against the American thing. So I would direct a specific question to Willie, which is, is there, how much work does Palestine and does Zionism over there do to help even Brandeis to make the claim about group rights in a softer way in the American context, right? In order to basically bifurcate his nationalism into something softer that can be about group rights and pluralism and American Jewish self-constitution here, but other things that involve a different kind of political culture, states, territory. It can only happen because of over there. And this is sort of a long way of something that I'm curious about, which is they are so aggressive in that Congress moment in the teens, and then it all kind of falls apart, right? And they don't push it. And I've always wondered about that, why even people like Horace Kalin, who is often celebrated by American historians as pushing the boundaries of pluralism, but he never really is willing to touch the law, right? He's never willing to say, okay, now we should enshrine more kinds of legal arrangements here. And I wonder about that and how that's playing out for Brandeis.
Okay, so we'll have the responses now. Maybe we'll begin from the end to the beginning.
Wow. So starting with the Brandeis of privacy, the Brandeis of I'm going to say least about that. I mean, that it's partly he's a younger man when he writes that, a much younger man, and more of a classic liberal. And I'm sure we could work through that these are not particularly inconsistent, the different arenas in which the intimate sphere in which the right to privacy is being constructed by Brandeis versus the senses in which he is asserting the right, the group rights. I'm not sure how deep the tension is. Anyway, he becomes, at a certain point, fairly early on, Brandeis loves every ideology but classic liberalism. So to some extent, he might say, I was young and foolish and craving to be just a plain old WASP classic liberal when I wrote The Right to Privacy. Who did he write it for? A bunch of his WASP liberal WASP clients. It was a scandal about a WASP wedding being photographed too much, in the then new mass media, right, and so on and so on. So I don't think by the time he's a mature thinker, either he would reconcile it or he would say that that was then, this is now. What work? I think Leora asks a very challenging sort of meta question about what work law does in shaping and constraining and articulating all these projects and ideologies versus identity politics. This law is simply the supple tool of identity politics and whatever work identity politics wants it to do. I think that in this case, law is, in a certain way, I mean, part of the answer to that is that it helps one get a kind of wedge into Jim's question, right? The sort of why doesn't hard law, as opposed to the softer law of cultural and political discourse, yield to this language That's a certain kind of work law does. It in the U.S. context, it forces group rights, right, on the ground to simply be absorbed into whatever administrative law and other kinds of law is doing the real work. Nevertheless, the other work law does is, I think, as I suggest, as an enormously, right, the sort of it authorizes and empowers a form of identity politics that is quite radical. And it serves elites. It's an arena where, you know, these can be negotiated. It is on the legal field, in the Bourdieu sense, that the sort of new immigrant working class and all their socialism and ethno-nationalist politics meets the ruling elites, right? And the compromises are worked out, so that it's the gentle civilizer of ethno-nations. It does a lot of that kind of cultural work. But all of that, you know, strikes me as Lior's questions are always sort of ones I can never answer. I don't know at the end of the day how I would, you know, just off the spur of the moment answer the question of what I think is the heart of your question, which I've more alluded than answered. But I'm not going to take any more time from my fellow panelists. Just one more, Scott's point, which is sort of what about what's going on in the U.S., what about African Americans? There are deep parallels, right? Du Bois is doing the same stuff as Horace Callan and the Russian diasporic nationalists. He's saying we want both. And he's a diasporic guy himself, right?
It's not from Russia, right?
Not Russia, I don't think. He's not Jewish, NJ also, right? But Du Bois is sort of trying to say we're going to create a form of liberal citizenship that we can make consistent. He sort of wants liberal citizenship, social citizenship, and pluralism. Liberalism, socialism, and pluralism. We can have it all, right? And there, sort of, it's no coincidence. He sort of drinks from the well of William James. They're trying, and he ultimately leaves the NAACP in sort of trying to put together national rights with individual rights. All that, and then finally, Callan, Brandeis, they invent ethnicity. They coin, you know, they coin the phrase, and most American historians will say they do so to show that Jews are not a race. I think that's bullshit. They do so to sort of soften what it is to be a race, but they are so that it's part of the work is we're not racialized the way people of color are, but more important work, I think, in the moment we're talking about is to say that all of these group differences in the United States are both sort of, it's sort of both given. They sort of use this organicist thing. It's born. It's tribal. But also historically constructed. Ethnicity is sort of in their head. First appears in a Callan and an Isaac Berkowitz in this moment. And they evade where blacks stand, whereas Louis Marshall and the classic, and now really shut up, the classical liberals are much bolder in some ways on the deepest race question of America. They're better, to put it crudely and politically, in some ways than a Brandeis or a Callan on African American, standing up for African Americans, and that's some work that law does too. They are classic liberal, sort of. Pardon me? They are out there, and it's only a later generation of leftists who catch up with them and become Jewish civil rights lawyers.
Marcus?
Okay. I will try to be brief. you presented some kind of duality, law versus identity. I try not to use the word identity because I don't know what it is. There are some words I am trying to avoid. It is one of them. But for the sake of our discussion, I think that instead of taking this dual paradigm of understanding the reality, I would like to propose a constructivist paradigm, which means that it is not two skills, identity politics and law, but both skills are constructed through as a result of a personal discursive construction of the reality, of the understanding of the reality. They understand in some way what is identity or what is their identity. They used to or try to act according to that. Also in the law, in the field of law, which in its way influence in a dynamic way to the identity. Be what could it be, and define this could be defined.
Yes.
That means it is a more complicated dynamic, it is dictated by the personal construction of the reality. That is the point. We can, of course, go further, but regarding the question of the tension and compatibility. Of course, sometimes it is understood as tension, especially for those who don't accept it, and the compatibility for those supporting it. But in any case, I would like to emphasize that we have to take into account maybe Brubaker's approach regarding nation states, and not only maybe we can talk not only about nation states but nationalizing states, which makes the question a little bit more subtle. Regarding Greenbaum and his position, of course, everyone changed because I don't know what is in identity. Everyone is not the same people, yeah, the same person. In Greenbaum too. Of course, that his role in 1905 in a very teeny, unimportant movement like the Zionist movement in 1905 in Russia, it was not the same person who was the speaker of the Jewish minority in the Polish Sejm, elected by a vast majority of the Jewish electorate in interwar Poland, and of course not the same person in coming to mandatory Palestine and later on in Israel. But you have to take into account that he was the first Minister of Interior, and in his role as first Minister of Interior, he was an agent of transference of cultural motives and practices from his own experience in Poland to the state of Israel, sometimes in a completely unaware way. Sometimes we can see it explicitly, like in those citations I presented briefly. That is one point. The second point is that for the sake of our discussion, it is easier to bring, big noun names, in spite that the daily life is constructed not only by the big names, but by ordinary people, and we can, of course, try to understand the transference of motives and cultural practices from Eastern Europe to the state of Israel, mainly through these ordinary people. Again, regarding also the question of what is a nation state, if could be compatible with minority rights or no, or it is not placed for minority rights.
Wow.
everybody wants coffee, so I'm going to be even briefer. Individual rights inadequate. In the work I do in international history, the assumption since 1648 was that there would always be minorities. But under largely imperial regimes, these minorities had a place and they were protected under certain kinds of laws, even in the Ottoman Empire. Everything changes in 1789 with the announcement that, to the Jews as individuals, everything is a people, nothing. This is the big thing, the nationalizing state. Throughout the 19th century, there still remains this fiction that we can make people follow whatever laws, Damascus, Dreyfus, horrors, a Frenchman has been unjustly tried. The whole business with the treaties at the Congress of Berlin, we're going to make these new states, obey their own laws and give citizenship. Oh, it doesn't happen. It's also, even in the United States and Britain, immigration restriction then becomes an issue as well. And minorities, we begin to see, are not permanent, and in fact they're in danger. In 1914, after the Balkan Wars, you have the beginnings of population exchange. These people are not wanted. They're not only going to be excluded, they're going to be exchanged. Then you come to the peace conference, and McCartney's got a very good line in National States and National Minorities, where he actually reads the first line of the constitutions of all the new states of Eastern Europe that begins, the Polish state is the homeland of the Polish people, excluding 6% of the population. And even more anomalous would be Czechoslovakia, et cetera, et cetera. So individual rights, in this kind of context is a serious problem. And yet the treaties maintain this fiction that we're only dealing with individuals. And that becomes, of course, a problem before 1933. I mean, as Wolff discovers in the case of Austria. I'm not going to say anymore. Thank you.
Okay, thank you very much for the three speakers.